She forged her license. She should be banned from practicing medicine for life. My sister did not look at the judge when she said it. She looked at the room. I kept my hands flat on the table. The air conditioning was running somewhere above us, that thin mechanical hum that fills every pause in a place where no one is allowed to move without permission. I could feel the edge of the table under my fingertips, the wood grain, the slight ridge where two pieces met, something to press against without anyone knowing I was pressing. There were 60 people in that gallery. I had counted them when I sat down, the way I count things when I need my mind to stay in one place. 60 people, and Hannah had positioned herself so that every single one of them could see her face when she spoke. I had watched her choose the position. She had made a small adjustment to her angle before she began speaking, a deliberate shift of maybe 2 degrees, and the adjustment had placed her face in profile to me and in full view of the gallery. She had known exactly what she was doing. She had always known exactly what she was doing when an audience was involved. My attorney leaned 3 inches toward me and dropped his voice to almost nothing. "Lily, say something. You need to say something right now." I did not say anything. I am 32 years old. I have been a licensed anesthesiologist for 4 years, board certified, on staff at one of the better hospital systems in the state. I have kept people alive in rooms where the margin between alive and not alive was thinner than the paper those records were printed on. I know how to hold still. She had finished speaking, but she had not sat down, and her body was angled not toward the bench but toward the gallery behind me, because she already knew where her audience was. She had always known exactly where her audience was. Gerald Fitch touched the edge of my sleeve. He had spent 11 years trying cases like this one. The touch was not a reassurance, it was a warning. "The jury is watching you not respond," he said. "I know," I said. The fluorescent lights overhead made everything in the room look slightly wrong. A woman in the second row of the gallery had a small notebook open on her lap and was writing something in it without looking down. The way people write when they are watching something they do not want to look away from. A man, 3 rows back, exhaled through his nose. That particular kind of exhale that means the person has already made up their mind. The judge had opened a folder on the bench in front of him and was turning pages without looking up. Gerald made a sound that was not quite a word. I had heard that sound from him before in the hallway 4 days ago when he reviewed the opposing counsel's filing for the first time. It was the sound a man makes when he is revising his confidence and does not want you to notice. Gerald was not a man who made that sound often. The fact that he made it now told me something about how the morning looked to him that no other signal had communicated as clearly. Hannah finally sat down. Her attorney stood up. Patricia Coles, dark suit, hair in a low knot, a habit of touching her collarbone before she spoke. "Your Honor, the plaintiff calls Dr. Renata Voss." Voss, a woman I had never seen before in my life, walked through the side door. She was perhaps 45, dark coat, careful posture, the kind that is practiced rather than natural. She took the oath with the steady deliberateness of someone who had said the words before, at least in rehearsal. She sat down in the witness stand and folded her hands in her lap and looked at the jury instead of the room, and something in my chest went very quiet. Not peaceful. The particular quiet that comes right before something goes wrong and you can feel it coming and you cannot stop it from arriving. I had seen her photograph. Gerald had obtained it 3 weeks ago, along with a documented history he had spent considerable time trying to pull apart. He told me the scenes were there. He told me we had the threads. Looking at her now, I was less certain about the threads. Patricia Coles began her examination. She asked Dr. Voss about the date of the alleged appointment, the time, the treatment room. She asked what I was wearing, and Renata Voss described a white coat with my name embroidered in blue thread above the left pocket. And in the gallery behind me, I could hear the particular quality of silence that means people have stopped shifting in their seats. Then she described the procedure. She named the steps, the instrument used, the concentration of the anesthetic compound, the aftercare instructions I had allegedly given her when it was done. I opened the small notebook on the table in front of me and wrote down 4 words. Wrong dosage. Wrong protocol. The concentration she described. The specific application sequence, the recovery instructions, none of it existed in our hospital's formulary. I had memorized every protocol we used, not because I was required to, but because 3 years ago, one deviation from one protocol was the only thing that had kept a patient alive on my table, and after that night, I did not trust myself to rely on memory that might be approximate. I knew our protocols the way I knew my own handwriting. What Renata Voss had just described was not our protocol. It was not any protocol I recognized from the peer-reviewed literature. The specific compound concentration she named was not only incorrect, it was a concentration that appeared in a single academic paper from 11 years ago, a paper that had been retracted the following year because of methodological errors in the underlying study. Someone had done research. They had simply stopped one layer too soon. She had been told what to say by someone who knew enough to sound convincing and not enough to know what a working anesthesiologist would catch on the first pass. I wrote a second line beneath the first. Check the formulary date. Gerald slid a legal pad 3 inches toward me without looking up from whatever he was writing. His note said, "I may need to call for a continuance." I put my pen to the pad and wrote beneath it, "No." He looked at what I had written. He looked at me. He had a particular expression he used when he was deciding whether to argue, a slight compression at the corners of his eyes, a stillness in the jaw that lasted 2 or 3 seconds and then resolved into something that was not quite agreement. He did not argue. I looked back toward the front of the room. Patricia Coles was asking Renata Voss to describe the harm she had suffered. Renata Voss's voice shifted. Registers when she answered, lower and slower, with a catch in it that did not quite become crying, but made the option available to the people listening. 2 jurors in the front row leaned forward at the same moment. A 3rd juror turned slightly in her seat to look at me, and I watched her do it without changing anything in my face. Then I looked at the gallery. My parents were in the 3rd row on the left side, where Hannah's attorney had placed them. My father was in the charcoal jacket he wore to funerals and to events he wished were already finished. My mother had her hands folded in her lap, that particular stillness the women in my family performed when they were waiting for something difficult to be over. They had arrived on the 2nd day of the trial. I had not spoken to either of them. Hannah had turned slightly in her seat and tilted her chin toward them, a small practiced gesture, almost casual. My father nodded. Not at anyone specific, not at Hannah. Just a slow, confirming movement, the way a person nods when someone is saying something out loud that they have already decided is true. My mother did not nod. She also did not look at me. I turned back to face forward. Renata Voss was still speaking. She had moved on to the lasting effects, the anxiety, the disruption to her daily life, the months of treatment required to address what I had allegedly done to her. Her voice had found its rhythm now, the slight catch appearing at regular intervals, just often enough to remind the jury it was there without tipping into anything that would seem performed. It was, I thought, genuinely skilled. Whoever had prepared her had done their work carefully. Gerald wrote something else on the pad and did not push it toward me this time. I looked over anyway. He had written, "They coached her well." Beneath it, after a moment, he added, "Too well." I looked at him. He was already looking somewhere else, but the corner of his mouth had moved, just slightly, in a direction that was not quite relief but was adjacent to it. He had seen the same thing I had seen. He had caught the gap between what she was describing and what the actual protocol required. He knew. I had not told him yet, but he knew something in her testimony had not held. That was the first moment since I sat down in that courtroom that morning that I allowed myself to breathe at something close to a normal depth. The judge had not looked up from the folder since he opened it. Renata Voss was describing her suffering, and the jury was watching her hands, and Hannah was watching the jury, and the gallery was watching the front of the room, and the one person with the authority to stop all of it was sitting behind 6 inches of raised bench, reading a document with the focused attention of a man who has found something he did not expect to find. He had read 4 pages. He turned to the 5th. He stopped. He went back to the previous page. He read the same passage again, and this time he did not move on immediately. He stayed there, on that page, for long enough that the court reporter's hands went still on the keys for a half-second. One juror glanced toward the bench. The man in the 3rd row of the gallery who had exhaled earlier went very quiet, as though he could feel the pressure change. The judge looked up. He did not look at Hannah. He did not look at Renata Voss. He looked at me. briefly, with an expression I could not read clearly from where I was sitting. It was not recognition. It was not suspicion. It was something more careful than both of those. The expression of a man who has just placed something he did not know he was looking for. Then he looked back down at the document. "Counsel," he said. Both attorneys looked up simultaneously. "Let me review this document." He did not say which document. He did not indicate what he had found in it or how long the review would take. He returned his attention to the page, and the room went into a silence that was different in quality from every other silence that morning. The kind of silence that is not the absence of sound but the presence of everyone in the room holding something they are not sure what to do with yet. 60 people in that gallery. Not one of them knew what was in that folder. I knew. I kept my hands flat on the table. I did not look at Hannah. I counted the seconds the way I count them in surgery. Not anxiously, not hopefully, just precisely, because precision is the only reliable thing when everything else is in motion. The judge turned to the 6th page. He did not put the folder down. The judge set the folder down at 4:17 in the afternoon. I know the exact time because there was a clock on the wall above the side door, one of those institutional clocks with a white face and a black second hand that moves in discrete ticks rather than sweeping, and I had been watching it with the same quiet attention I had been giving everything else in that room since 9 that morning. The second hand moved. The minute hand did not. Gerald was still writing on his legal pad, and Renata Voss had been excused from the stand 20 minutes earlier, and the gallery had thinned slightly during the afternoon recess, 43 people now where there had been 60. But my parents were still there in the 3rd row, and Hannah was still at the plaintiff's table with her hands folded and her attorney beside her. And none of it had changed except that the judge had finally set the folder down. He called an end to the session for the day. He did not explain what was in the folder. He did not indicate what the review had produced. He thanked the jury for their patience, reminded both counsels of their 9 o'clock start the following morning, and left the bench with the folder under his arm. Hannah turned to look at me as the room began to move. I was already looking at Gerald. "Tomorrow," I said. "Tomorrow," he agreed. Outside the courthouse the air was cold and smelled like rain that had not arrived yet. That particular metallic sharpness that comes when weather is building and the sky does not know it yet. Gerald walked with me to the corner and said he would call me that evening to go over preparation for the next day's session, and I told him that was fine. And then I stood there alone for a moment on the sidewalk outside a federal courthouse while people moved past me, and I watched the traffic, and I did not feel anything yet. That was normal. I had learned years ago that the feeling comes later in smaller rooms when there is nothing left to count. The hotel I was staying in was 4 blocks away. I had booked it myself, a mid-range business property with a lobby that smelled like carpet cleaner and lobby coffee. Nothing remarkable, nothing that required anything from me. I had a room on the 7th floor with a window that faced the parking structure next door. I had stayed there for 9 days. I sat on the edge of the bed and I called no one. That was not new. That had been the pattern for a long time. I had not always understood it as a pattern. When I was younger, I had thought of it as a personal preference, an introversion, a professional habit of self-containment. I had been in medical school when I first started to notice that the people around me called home during hard weeks, called friends, called someone, and I did not. I would look at my phone and think about calling, and then I would not call. And I had told myself for a long time that this was simply who I was. It was not until I was 26, sitting in a hospital break room at 2 in the morning after a shift that had taken something out of me I was not sure I could replace, that I finally called home. My mother answered on the 3rd ring. I told her I was struggling, not the details, not the specific case that had gone sideways, just the shape of it. I was tired. I was behind on rent. I had made a decision in an operating room that had turned out to be the right decision, but had not felt that way for 6 hours afterward. And 6 hours of not knowing whether you saved someone or lost them is a particular kind of exhaustion that does not respond to sleep. My mother listened. There was a pause, the brief pause of someone arranging a response. Then she said, "You'll be fine. You always are." And she hung up. I sat in that break room for a while afterward holding the phone, not upset exactly. More like something had been confirmed that I had suspected for a long time and had kept hoping would turn out to be wrong. I did not call back. I went back to work. That was the first time I remember hearing the sentence. It was not the last. I heard it. The Christmas. I was 27 when I mentioned over dinner that I was still paying off the last of my undergraduate loans on top of my medical school debt, and my father said without looking up from his plate that I would be fine. I always figured things out. I heard it this spring. I was 28 when I called to say I had been placed on a performance review at work for a documentation error, and my mother said the same thing she always said. I heard it the summer I was 29 when I needed someone to co-sign an apartment lease because my debt-to-income ratio was too high, and I called home and my mother said they could not do that right now, and then she said the sentence, quietly at the end as a kind of punctuation. You'll be fine, you always are. It was said without cruelty. That was the thing I had to keep reminding myself in that hotel room, sitting on the edge of the bed in the dark with the parking structure visible through the window. The sentence was not delivered with any intention to wound. My mother said it the way she said everything that was not about Hannah, with a kind of absent-minded confidence, the way you confirm a fact you checked once years ago and see no reason to verify again. The problem was not the sentence. The problem was what existed around the sentence, in the space where something else should have been. I had spent a long time not letting myself look directly at that space. My parents had 2 daughters. One of them had always needed more. This was a fact established so early in our family's history that by the time I was old enough to observe it, it was simply the architecture of the house we lived in. Hannah needed more attention, more reassurance, more intervention. Hannah's teachers needed to be called. Hannah's feelings needed to be carefully managed. Hannah's opportunities needed to be created, explained, navigated on her behalf, because Hannah found the world more difficult than I did, and that required resources that were finite. I had found the world difficult too. I had simply not found a way to make that visible. I was 9 years old the first time I stayed up past midnight to finish something that was not my own work. Hannah had a history project due the following morning. She had known about it for 2 weeks. She had spent those 2 weeks doing other things. And by 10 o'clock the night before it was due, she was crying at the kitchen table, and my mother was sitting beside her, and my father had his coat on because he was going to the 24-hour pharmacy to get poster board. And I went to my room, and I got out the encyclopedia, and I started taking notes because I was faster at this than Hannah, and if I did not help, it would not get done, and if it did not get done, Hannah would be miserable, and when Hannah was miserable, the whole house arranged itself around that fact. I did the project. Hannah presented it. She got a B+. No one mentioned that I had done it. I did not expect them to. The years that followed had that same shape, again and again, with variations. I tutored Hannah through high school. I wrote the first draft of 2 of her college application essays because she sat at the kitchen table crying and said she did not know how to start, and I knew how to start, and the path of least resistance in our house had always been for me to do the thing, rather than wait for the difficulty of it to resolve some other way. When Hannah got into a mid-tier school in the same state and my parents took her to dinner to celebrate, I was at a library study group preparing for an AP examination. No one suggested changing the dinner reservation. I told them to go ahead. You'll be fine, my mother said. You have your study group. I went to a state school on an academic scholarship. I worked 20 hours a week through my undergraduate years. I graduated at the top of my program and applied to medical school and got in and told my parents over the phone because they were at one of Hannah's events that weekend and the timing had not aligned. Hannah, in those same years, enrolled and withdrew from 2 different certificate programs. She worked a series of jobs in medical-adjacent settings, a clinic receptionist, a phlebotomy assistant, a dermatology lab technician, accumulating knowledge the way someone does when they are in proximity to expertise without having pursued it formally. She had always been interested in medicine, or in the version of medicine that existed in the before and after photographs on the walls of waiting rooms. In the vocabulary and the tools and the white coat and the particular quality of deference that came with the title. She understood the surface of it. She had spent years standing close to the surface. She did not have the title. I did. And the gap between those 2 facts had been, for Hannah, an arrangement she had not been able to accept. I had understood for several years that Hannah resented this. I had not understood, until the lawsuit was filed 8 months ago, exactly what she planned to do with the resentment, that I had operated an unlicensed dermatology practice under false credentials. It alleged that I had seen patients without proper authorization, performed procedures I was not qualified to perform, and caused harm to at least one patient, the woman named Renata Voss, who had wept in the witness stand that morning with such careful, calibrated effectiveness. The lawsuit sought damages. It also sought, in a separate motion filed 3 weeks after the initial complaint, the revocation of my medical license. When Gerald first called me to say the motion for revocation had been filed, I was at the hospital finishing a double shift. I sat in my car in the parking garage and read the filing on my phone, slowly, twice. Then I sat there for a while longer. My first thought was not about the legal exposure. It was a simpler and more exhausting thought. The thought of someone who has been expecting a particular thing for a long time and has finally seen it arrive. Of course, I thought. Of course this is what it became. I had known, in the way you know things you cannot yet prove, that the clinic was at the center of this. I had opened the clinic 2 years earlier, quietly, through a holding company, using savings I had accumulated over 4 years of double shifts and careful living. It was a small operation, 3 treatment rooms, a part-time staff of 2, focused on cosmetic dermatology procedures. I was not only qualified to perform, but had been performing in hospital settings for 3 years prior. I had kept it separate from my hospital work deliberately, not because there was any conflict, but because I had learned early that the things I built tended to attract attention from the people in my life who had not built them. Hannah had found out about the clinic 14 months before she filed the lawsuit. I did not know how. I had taken considerable care, but she had found out, and I knew she had found out because of a conversation at our parents' house the following Thanksgiving. A conversation in which Hannah made 2 references to a clinic in a way that was slightly too casual, the way people are slightly too casual about things they are working to appear uninterested in. I had said nothing. I had filed the conversation away. 8 months later, the lawsuit arrived. I lay back on the hotel bed and looked at the ceiling, and I thought about Renata Voss's hands in her lap and the way my father had nodded in the gallery, that slow, confirming movement that required nothing from him, no investigation, no question, only the already established belief that if Hannah was saying something, it had the weight of family truth behind it. He had nodded the same way at Hannah's history project presentation, the same way at her community college enrollment, the same way at every version of Hannah's life that had been presented to him as an accomplishment, regardless of the architecture underneath. I was not angry at my father. That was the honest answer. I had spent a long time in my 20s being angry at him and at my mother both, and at some point, the anger had resolved into something more like understanding, the recognition that my parents were not malicious people, but people who had organized their family around the axis of the child who required the most visible tending. I had been, from the beginning, too capable of tending myself. They had taken me at my own word. The mistake was mine, in some ways. I had been so committed to not needing anything that I had become invisible in the places where visibility would have helped. But the clinic was not invisible. The clinic was real. The holding company was real. The documentation was real. 4 years of double shifts and 1 careful legal structure, and the fact that I had, for reasons that had nothing to do with Hannah, kept meticulous records of everything I had ever done in a medical setting. Every protocol deviation, every outcome summary, every case note. The clinic's own records were equally complete. 4 years of patient intake forms, treatment notes, before and after documentation, insurance filings. Every procedure I had performed was on paper, in order, cross-referenced against the relevant medical literature and the applicable standards of care. I had not built it to survive a lawsuit. I had built it the way I built everything, which was the only way I knew how to build anything. I reached over and turned off the lamp. The parking structure outside the window was still lit. I could see the grid of it through the curtain, that orange-gray light that is the particular color of cities at night, the light that does not change whether you are awake or asleep, whether the day has gone well or badly, whether something is almost over or just beginning. I thought about the folder. I thought about what was in it and what would happen when the judge finished reading it and what the room would look like in the morning. And I did not let myself feel anything about any of it yet because there was still work to do, and the work required the same thing it had always required from me. The same thing that had apparently been visible to everyone who had ever trained under me or worked beside me, the thing my parents had named without understanding what they were naming when they said it. "You'll be fine. You always are." Yes, I thought. I closed my eyes. I had always been fine. That had never been the point. Gerald called at 8:47 that evening. I was still on the bed, not sleeping, doing the thing I do when I need to think without thinking, which is to count the orange rectangles of the parking structure through the gap in the curtain. There were 42 visible from where I was lying. I had counted them 3 times, and each time I arrived at the same number. And I allowed the number to be reliable even though I was aware that nothing else in my present circumstances was extending me the same courtesy. "The records they submitted today," he said without preamble. "Walk me through them." I sat up. "What specifically?" "The treatment record for Voss. The one entered as Plaintiff's Exhibit 7. I've been looking at it for the last 2 hours. "It's fabricated," I said. A pause. "Tell me what you see." "The header formatting is from our hospital's electronic record system. The template version they used was retired 14 months ago. We migrated to a new system across the whole department. Anyone currently working in that building would have generated a record on the new template automatically. The only way to produce a document on the old template is to have accessed the system before the migration or to have exported the template file at some point prior." Gerald was quiet for a moment. "Can that be proven?" "The IT department logs every access event. Every document opened, every template pulled, every export. It's automatic. It runs in the background whether anyone is paying attention or not." Another pause, longer this time. "Lily," he said, "why are you telling me this now?" "Because now is when it's useful," I said. He made a sound I had learned to interpret as him writing something down quickly. "I'm going to need to file a motion for discovery on the hospital's IT access logs first thing tomorrow before the session opens. I want to have it in front of the judge before Coles puts another witness on the stand." He paused. "Is there anything else I should know about before tomorrow?" I looked at the parking structure through the curtain. "Not yet," I said. I did not sleep well. I slept in the way you sleep when your mind has located something. It refuses to release entirely. Short stretches of dark, and then a surfacing. A return to the ceiling, a return to the count of orange rectangles. At some point after 2 in the morning, I got up and made coffee with the small machine on the bathroom counter and sat at the desk and opened the legal folder I had been carrying for 8 months. The one I had assembled myself methodically the way I assembled anything that mattered. I had started it the week after the lawsuit was filed, not because I was afraid, because I had learned, early and at some cost, that the difference between surviving something and not surviving it is usually the quality of your records. The folder contained 4 years of shift logs, case summaries, outcome reports, protocol deviations with their documented justifications, continuing education certificates, peer review evaluations, every piece of paper that constituted the official record of who I was as a physician. It also contained the holding company documents for the clinic, the licensing filings, the insurance certificates, the lease, the staff contracts, the equipment invoices, every document that confirmed the clinic was real and legitimate and mine. And near the back, in a section I had labeled simply with a date, it contained a single printed email chain. I did not look at that section. I knew what was in it. I had known for 18 months. I closed the folder and went back to bed, and this time I slept until 6. The courthouse was cold in the way that institutional buildings are cold in the morning. The heat not yet fully circulating, the marble floors holding the night temperature against the soles of your shoes. Gerald met me in the lobby at 8:15 with coffee in a paper cup and the expression of a man who had filed a motion at 6 in the morning and was waiting to see what it produced. "Judge Hale granted the discovery request," he said, handing me the cup, 45 minutes ago. "The hospital's IT department is pulling the access logs now. We'll have them by midday." I wrapped both hands around the cup. "And Coles has been notified. She requested an emergency conference with the judge before the session opens. It's happening right now in chambers." He looked at me steadily. "She's not happy." "No," I said, "she wouldn't be." The morning session opened at 9:12, 12 minutes behind schedule. The gallery had filled back to its original number, 60 people, perhaps a few more. The jury filed in with the careful, neutral expressions of people who have been instructed repeatedly not to form opinions and are working hard at it with varying degrees of success. Patricia Coles called her next witness at 9:18. His name was Dr. Warren Fields, a medical licensing consultant retained by the plaintiff to review my credentials. He was perhaps 55 gray at the temples, the kind of careful professional witness who understood that his job was to establish doubt rather than certainty, to introduce questions into the air of the room and leave them there for the jury to breathe. He testified for 40 minutes. The substance of his testimony was that a search of the state medical licensing database conducted 6 weeks prior to the trial had returned no active license for a Dr. Lily Moore in the specialty of anesthesiology. He had screenshots. He had a printout. He had a time-stamped confirmation from the database's own verification system. Gerald cross-examined him for 11 minutes. He established that the search had been conducted once on a single date using a single search parameter. He established that database records were subject to administrative delays and that a search conducted on any given day might not reflect updates processed within the previous 72-hour window. He established that Dr. Fields had not contacted the licensing board directly to request a certified confirmation, but had relied solely on the automated search function. He asked whether the automated system provided any disclaimer about the currency of its results. Dr. Fields acknowledged that it did. It was good work. I watched the jury while Gerald did it, and I could see two of them recalibrate slightly, the particular microadjustment of people who have just been given permission to doubt something they had decided to believe. But Dr. Fields was also good work. On the other side, he was unflappable. He acknowledged Gerald's points with the gracious composure of someone who has given testimony many times and knows that acknowledging a small point costs nothing if you are confident in the large one. When Gerald finished, the jury had doubt in addition to what they had before, but they also still had what they had before. Patricia Coles called her third witness at 10:37, Dr. Elaine Brooks. I had known this was coming. It had been in the witness list for 6 weeks. I had read Elaine's name on that list, and I had felt something move in my chest that was not quite betrayal, because I understood why she was there, but that was not entirely unlike betrayal either. Elaine Brooks was 61 years old and had been the chief of anesthesiology at our hospital for 9 years. She had hired me 4 years ago out of my residency program, had mentored me through my first complex cardiac cases, had written 2 of the strongest letters of recommendation I had ever received. She was rigorous. She was fair. She was also the kind of woman who believed with the earnest conviction of someone who had earned her position through decades of institutional loyalty, that the proper response to a complaint was to take it seriously first and investigate second. In her world, that sequencing was a virtue. I had never disagreed with her about it. I disagreed with nothing about who Elaine Brooks was. She had simply been given incorrect information by a process she had trusted, and she had reported that information, and she was here now because of it. Patricia Coles asked her if she had any concerns about my practice in the 18 months prior to the lawsuit. Elaine looked at her hands for a moment. I had some concerns, she said. Yes. The gallery shifted. Not dramatically, not in any way a camera would have caught, just that collective slight movement of people leaning a fraction of an inch toward something. Coles asked her to describe those concerns. Elaine described a case review she had initiated 7 months before the trial, following an anonymous complaint submitted to the department's internal ethics channel. The complaint had alleged that I was conducting procedures outside my scope of practice. She had reviewed my case files for the relevant period. She had not found conclusive evidence of misconduct, she said, but she had found some documentation gaps that she had flagged for follow-up. Gerald objected twice during this testimony. He was overruled once and sustained once. The sustained objection removed a specific statement that would have been worse, but what remained was still in the room, still in the air, and the jury was still breathing it. When Patricia Coles finished and sat down, Gerald rose for cross. He asked Elaine whether she had completed the follow-up reviews she had initiated. She said that the filing of the lawsuit had made it difficult to proceed with an internal review while legal proceedings were active. He asked whether the anonymous complaint had ever been traced to a specific source. She said it had not. He He asked whether she was aware of any regulatory body that had taken formal action against my license based on the concerns she had described. She said she was not. He asked whether, in her professional opinion as the chief of the relevant department, I was a competent physician. She paused for a moment that was a fraction too long. Yes, she said, she is. Gerald sat down. I wrote nothing in my notebook during Elaine's testimony. I kept my hands on the table and I watched her, and I thought about the first complex cardiac case she had walked me through, standing at my shoulder in the operating room at 1 a.m. Her voice quiet and precise, telling me what she was seeing in the monitor readings and asking me what I saw. The pedagogical patience of someone who understood that competence was built one careful question at a time. She had taken a complaint seriously. That was not a betrayal. That was who she was. I looked down at my notebook. The wrong dosage detail was still written there. The 2 lines I had made during Renata Voss's testimony. I looked at them for a moment, and then I turned the notebook over so the lines faced the table. The morning session broke for recess at 11:50. 15 minutes. Gerald went to make a phone call about the IT logs. 2 of the jurors walked toward the water fountain at the end of the hall. The gallery thinned quickly, people stepping out into the corridor, the low sound of a dozen conversations starting at once beyond the doors. I went the other way. There was a small room behind the courtroom, accessible through a door near the stenographer's station that the bailiff had left unlocked during recesses. It had a table and 4 chairs and a window that faced a concrete wall and nothing else. I had used it twice before during this trial when I needed somewhere that was not the corridor and not the gallery. I sat down at the table. I took out my phone. I opened the email application and navigated to a folder I had created 18 months ago and labeled with no name, only a date. There was 1 item in it, a chain of 3 emails, the first sent from an address I did not recognize to an address at the hospital's administrative domain. The second, a reply. The third, a forward that had found its way to me through a circuitous route I had never fully traced, arriving in my personal inbox on a Tuesday morning when I was between cases. I had not been the intended recipient. I had not been mentioned in it. What it contained was a conversation between 2 people, one of whom I recognized by the hospital domain address, in which the existence of the clinic was discussed, in which the holding company structure was referenced, and in which one party suggested that a complaint filed through the right channels could force a licensing review that would create the appearance of impropriety even if nothing improper had occurred. I had printed it. I had kept it. I had given a copy to Gerald on the day he took my case. The access logs Gerald had requested this morning would tell us who at the hospital had accessed the electronic record system in the period when the false treatment record would have been created. The email chain would tell us who had the motive and the knowledge to create it. Together they would tell the jury a complete story. I put the phone away and looked at the concrete wall through the window, and I sat in the particular quiet of a room that no one else is using, the quiet that does not require anything from you. And I let 2 minutes pass without counting anything. Then I went back into the courtroom. The afternoon session opened at 1. Gerald's motion for discovery had produced records. A hospital IT administrator named Marcus Reed testified about the hospital's electronic record system. He described the migration timeline, the specific dates, the department-by-department rollout, the window during which both systems had run in parallel before the legacy version was fully retired. He described the logging protocol, how every access event was automatically recorded with a timestamp and a user credential, how the logs ran continuously in the background, whether anyone was monitoring them or not. He described what would have been required to generate a document using the retired template after the migration cutover date, a valid credential, and either retained access through an oversight in the revocation process or an export of the template file during the overlap period. Either scenario would have left a log entry. Gerald asked him to describe the access log entry that matched those requirements. Marcus Reed read from the printed log. A user credential registered to a Kyle Brennan, a former contract administrator whose access had not been revoked after his contract ended 11 months prior, had accessed the record system on a date 7 weeks before the trial, and had exported the retired template file. The timestamp was consistent with the creation date embedded in the metadata of Plaintiff's Exhibit 7. Kyle Brennan. I had not heard the name before. Gerald told me, 3 weeks into my case preparation, that a man by that name appeared in the holding company registration documents for a shell entity called Meridian Consulting Group. Gerald had given me the name the same week he gave me the photograph he had obtained, the photograph of Kyle Brennan standing in a restaurant booth across a table from my sister. The photograph dated 11 months before the lawsuit was filed. Coles objected 4 times during Marcus Reed's testimony. She was sustained on 2 narrow points that required Gerald to rephrase specific questions. The substance of the access logs remained before the jury unchanged. There is a difference between the fact and the record of the fact. I had known that since medical school, since the first time an attending had told me that an intervention undocumented was an intervention that did not exist, not in any legal or institutional sense that could protect the physician or the patient. Kyle Brennan had accessed the system. The system had noted it. The note was now in the jury's hands. Gerald entered the financial records next. He put the clinic documents on the screen. My name, my license number, the date of the holding company registration, the property lease, the equipment purchase records, the staff contracts, the liability insurance certificates, the patient intake forms bearing the clinic's name. He let the jury look at all of it for a long moment before he said anything. Then he said, simply, that the defense wished the record to reflect that the medical practice at issue in his proceeding was a legally licensed operation owned and operated by the defendant, Dr. Acted by Lily Moore, who held full credentials to perform every procedure offered at the practice and who had held those credentials continuously throughout the entire period covered by the plaintiff's allegations. The room did not make a sound. I felt it change rather than heard it, the same pressure shift I had felt when the judge stopped on the 5th page of the folder. A change in the quality of the air, a collective adjustment in the people around me that registered in the body before it could be named. Hannah's stillness changed. That was what I watched. Not the jury, not the gallery, not Patricia Coles reaching for her notepad. I watched Hannah, and what I saw was the specific quality of stillness that is different from composed stillness. The stillness of someone who has just encountered a fact that their operating model had not included and who has not yet found the response to it. She had not known the clinic was documented this way. She had known it existed. She had known my name was connected to it somewhere in the corporate structure. But she had not known, or had not believed, that the documentation would be this complete, this clean, this entirely unambiguous. She had built her lawsuit on the assumption that what I had built quietly, I had built carelessly, because that was the logic of her model of me. The silence, she had always concluded, meant the absence of preparation. The quietness meant the absence of structure underneath. She looked at the screen. Then she looked at her attorney. Patricia Coles was already writing, her pen moving quickly, her face giving nothing away to the gallery, but her hand had tightened on the pen. The knuckle closest to the nib had gone slightly pale, just enough to be visible from where I was sitting if you were looking for it, and I was looking for it. Judge Hale called a recess at 11:15. I was gathering my notepad when the bailiff appeared at Gerald's elbow and said something quietly. Gerald listened, nodded, and turned to me. The judge wants to see both counsels in chambers, he said, and he's asked that you be present. We walked through the door behind the bench, into a corridor, and then into a room that was smaller than I had expected, wood-paneled, a desk with a green lamp, 2 chairs facing it, and 2 more against the wall. Judge Hale was already seated when we came in. He did not have his robe on. He was in his suit jacket, and he looked, without the bench between us, like a man in his mid-60s who had been reading carefully for several days and had arrived at something he needed to address. He asked the bailiff to close the door. He looked at all of us for a moment. Then he said that before the afternoon session began, he needed to disclose something on the record, and he would do so formally when the session resumed. But he wanted counsel to be aware in advance. He said that he recognized the defendant. He said it plainly, without preamble. He said that approximately 3 years prior he had been a patient at the hospital where Dr. Moore was on staff, that he had been admitted through the emergency department with a cardiac event, and that Dr. Moore had been the anesthesiologist on the case. He said he had not made the connection immediately when the case was assigned to him because he had known her only in a clinical context, and the name had not triggered recognition without the visual association. He said he had made the connection during his review of the materials in the folder, which had included a case summary from the relevant date. He said he was prepared to recuse himself and transfer the case to another judge if either party requested it. Patricia Coles said immediately that the plaintiff requested the recusal. Gerald looked at me. The room was quiet. The green lamp on the desk was the only light besides the window. Outside the window there was a narrow view of the street, a strip of gray sky, a piece of a building across the way. Gerald said that he needed 5 minutes to consult with his client. Judge Hale nodded and stepped out. Coles and her associate remained at the far end of the room. Gerald turned his back to them and spoke to me in a voice low enough that it did not carry. "If Hale steps down, we get a new judge," he said. "New judge means a new timeline for the evidence we entered this morning. Minimum 6 weeks before we can expect a hearing on the discovery materials. Everything we have still holds. The IT logs don't change, the financial records don't change, the holding company documents don't change. We still win." He paused. "But it won't be today." He looked at me steadily. "It's your call." I looked at the window, the strip of gray sky, the piece of building. I thought about what it meant to wait 6 more weeks in a hotel room 4 blocks from a federal courthouse with an orange parking structure outside the window and a thermostat set to 68 degrees. I thought about 6 more weeks of Gerald making early calls and the jury being held in suspension, and Hannah sitting at her table with her hands folded and her composure intact and the performance still running because the performance had not yet been required to stop. I thought about Robert Hale in an operating room 3 years ago with his heart stopped on the table and 48 seconds of silence before the call I made outside the protocol worked and the monitors changed and the room came back to the sound of a heart doing what a heart is supposed to do. He had remembered on his own. He had found the document himself in a folder that had been prepared and placed in front of him without explanation. He had disclosed it without being asked because he was a man who understood that the integrity of a proceeding depended on the integrity of the people running it. He was exactly the judge I needed. "We keep him," I said. Gerald held my gaze for 1 second. Then he turned back toward the room. When Judge Hale returned, Gerald informed him that the defense declined the recusal offer. The judge noted both parties' positions on the record. Coles entered a formal objection that was acknowledged and logged. Judge Hale said that he was satisfied the disclosure had been handled appropriately and that the case would proceed. We returned to the courtroom at 11:43. The gallery had not dispersed during the extended recess. People had shifted in their seats but remained. The particular persistence of an audience that has sensed the story is not finished. The jury was brought back in at 11:48. Gerald entered the bank records at 11:52. He walked the jury through the 3 wire transfers from the Meridian Consulting Group account to Renata Voss. The dates, the amounts, the total. He noted that the Meridian Consulting Group was a limited liability company whose registered agent was Kyle Brennan, the same individual to whose residential address the hospital's IT access events had traced. The first transfer had been made 8 weeks before Renata Voss appeared on the plaintiff's witness list. The second had been made 3 weeks before her deposition. The third had been made 4 days before the trial began. Patricia Coles objected 3 times during the presentation of the bank records. She was overruled twice and sustained once on a narrow evidentiary point that required Gerald to rephrase a single question. I watched Hannah. She was looking at the bank records on the screen with an expression I had not seen from her in 3 days of testimony, an expression I recognized from further back than the courtroom, from years of family dinners and holiday gatherings and phone calls. The expression she wore when a situation had moved outside the edges of the script she had prepared, and she had not yet found the line she was supposed to say next. Her attorney touched her arm once, briefly. Hannah did not respond to the touch. She was looking at the screen. The clinic documents were still projected on the left panel of the display. My name, my license number, the date of the holding company registration, all of it still visible. And now, beside it, on the right panel, the wire transfer records, the 3 payments, the name of the account, the name of the registered agent. The 2 things together. The jury could see both panels simultaneously. I watched one juror in the back row look from the left panel to the right panel, and then look at Hannah, and then look back at the front of the room, and the movement of his eyes told me everything I needed to know about what the shape of the case looked like from where he was sitting. Gerald sat down at 12:09. Judge Hale called a lunch recess. Hannah stood from the table and turned, and for one moment she looked directly at me across the 12 feet of courtroom floor between us, not with the performed composure she had been wearing since the first day, with something stripped of that, something underneath it, the expression of a person who has just understood that the variable they failed to check was the most important one. I held her gaze for exactly as long as it took her to look away. Then I turned and gathered my documents and followed Gerald toward the door, and I did not look back at the display screen or at the gallery or at the two people in the third row on the left side who had not moved from their seats when the recess was called. The work of the afternoon was still ahead of us. I was not done yet. I ate nothing. Gerald and I sat in a small conference room 2 floors below the courtroom with the door closed, and he walked me through the afternoon sequence twice. Not because I did not understand it, but because Gerald processed things by saying them aloud, and I had learned to give him the space to do that without interrupting. He laid the documents in the order he planned to present them. He told me what he expected Coles to object to and how he planned to respond. He told me the bank records were the piece most likely to produce a motion for dismissal from her side, and that he was prepared for it. I listened, and I drank the coffee someone had left on the table, and I looked at the wall, and I thought about sequence. At 12:58 we went back upstairs. The gallery had refilled completely. More people than the morning session, which meant word had moved through the building during the recess, the particular velocity of information in a place where people spend their days watching other people's reckonings. I sat down and placed my notebook in front of me and my pen beside it, and I looked at the front of the room. Hannah was already at the plaintiff's table. She had recomposed herself during the break. The performance was back in its correct position, the hands folded, the chin level, the attention directed toward the bench with the appearance of patient confidence. But the performance was sitting slightly differently than it had before, the way a garment sits differently after it has been wet and dried. The same shape, but with the memory of the disruption visible if you knew what you were looking at. The composure was intact. The confidence was not. I knew what I was looking at. Judge Hale took the bench at 1:04. Gerald rose immediately and said the defense was prepared to call its next witness. He called Marcus Reed back to the stand, not for new testimony, but to enter the IT access logs formally as a physical exhibit, walking the jury through the printed version of what they had seen on the screen that morning page by page, so that the documents themselves were in their hands rather than on a display they had watched from a distance. There is a difference between watching evidence and holding it. I had known that from the first day of medical school, from the first time an attending had placed a physical chart in my hands rather than describing it, from the specific weight of paper that means something is real and not theoretical. Gerald knew it too. He had designed the afternoon to put weight in the jury's hands. Coles objected twice. She was overruled both times. Marcus Reed was excused at 1:31. Gerald entered the financial records next, the full bank documentation now. Not just the 3-wire transfers, but the complete account history for Meridian Consulting Group going back 14 months. He moved through it with the same methodical clarity he had brought to everything that day, establishing the account's activity, its deposits, its single consistent pattern of outflow directed toward Renata Voss. He noted that the account had received no deposits in the 60 days following the filing of the lawsuit. He noted that the account had been closed 11 days after Renata Voss's deposition. He noted that the registered agent for the account, Kyle Brennan, had no documented professional relationship with Renata Voss that would explain the payments in any commercial or contractual context. Coles objected to the characterization. Gerald withdrew the characterization and simply read the numbers aloud again without commentary and let the jury sit with them. At 2:15, Gerald called his final witness. Doctor called his final witness. Elaine Brooks walked to the stand for the second time with the same upright posture she brought to everything. Gerald asked whether, since giving her testimony earlier in the proceedings, she had conducted any additional review of the relevant case records. She said that she had. She said she had reviewed the original case files from the period referenced in her earlier testimony, the files as they existed before the hospital's electronic records migration 14 months prior. She said that the documentation gaps she had described in her earlier testimony were the result of a timestamp discrepancy introduced during the migration process, The records existed. They had existed continuously. The migration had imported them with incorrect timestamps that made them appear out of sequence, but the underlying data was complete and intact. She said that she had been incorrect in her earlier testimony. She said she wished to correct the record. Gerald asked whether, based on her review of the complete and correctly sequenced records, she had any remaining concerns about my practice during the period in question. Elaine looked at me then, directly, for the first time since she had taken the stand the first time. Her expression was the one I recognized from the operating room. The expression she had when she was saying something she knew to be true, with the confidence that comes from having verified it yourself, rather than been told it. "None," she said. Her documentation was thorough. Her outcomes were consistent with best practice. I should not have characterized my earlier concerns as anything more than a preliminary flag that further investigation resolved. Coles cross-examined her for 22 minutes. She asked whether Elaine's review had been conducted independently or at the request of defense counsel. Elaine said she had initiated it herself the previous evening, following her own reassessment of what her earlier testimony had implied. She asked whether Elaine had been in communication with defense counsel prior to her review. Elaine said that Gerald had contacted her office to inform her of the IT access findings and that she had made the decision to review the records before hearing the specifics of those findings. She asked whether the timestamp discrepancy had been reported to the hospital's IT department. Elaine said she had filed a report that morning. When Coles sat down, the jury had Elaine's retraction alongside everything else they were carrying: the IT logs, the financial records, the holding company documents, and the specific sequence in which Gerald had assembled them over the course of the day. I watched two jurors make notes simultaneously and thought about Gerald saying that the two panels on the display screen told the whole shape of the story and thought that he was right. The shape was visible now to anyone in that room who was paying attention. Gerald entered the final exhibit at 3:41. It was a single document, 1 page. The case summary from March 14th, 3 years ago. Patient name, Robert Hale. Age, 61. Admission, emergency cardiac event, taken to the operating room within 40 minutes of arrival. Anesthesiologist, Dr. Lily A. Moore. Near the bottom, under clinical notes, a paragraph that described a moment 48 minutes into the procedure when the patient's heart had entered a rhythm that the standard protocol medication was not resolving. The note described the assessment I had made in the following 90 seconds, the decision to increase the dosage beyond protocol guidelines, the documentation of that decision in real time, and the outcome, restoration of normal sinus rhythm at the 49-minute mark. Patient stable. Procedure completed without further complication. Gerald did not comment on the document. He entered it into evidence and placed a copy on the bench in front of the judge and sat down. The room was quiet. Judge Hale looked at the document. He did not look at it the way he had looked at the other exhibits that day, with the attentive professional neutrality of a judge reviewing evidence. He looked at it the way a person looks at something they have not seen in 3 years and did not expect to see again, a recognition that moves through the body before it reaches the face, that arrives in the stillness before the expression. He read the clinical notes section. He read it again. Then he looked up. He looked across the courtroom, past Gerald, past the plaintiff's table, directly at me. The fluorescent lights ran overhead in their mechanical hum, and the court reporter's hands were still on the keys, and the gallery behind me was completely silent, in the way that 60 people are silent when they have collectively stopped breathing and do not know they have done it. Judge Hale said 3 words. I remember her. He said it the way a person says something that is not testimony or ruling or procedural direction, but simply true, a statement that exists outside the formal grammar of the room, that lands in the space where the formal grammar stops and the human fact begins. Coles was on her feet before the echo of it finished. She argued that the judge's statement constituted a breach of impartiality that could not be remediated by disclosure alone, that his visible recognition of the defendant created an appearance of bias that required an immediate recusal and a mistrial declaration. She argued it quickly and with force, and she touched her collarbone twice during the argument, and both times her hand returned to the table faster than it had the first time. Judge Hale listened to her complete. Then he said that the matter of his prior disclosure had been addressed on the record during the morning recess, that both parties had been given the opportunity to request a recusal at that time, that the defense had declined and the plaintiff's request had been overruled, and that his statement had been a personal response to documentary evidence properly entered before the court and did not constitute a ruling or an expression of favorable treatment. He said the motion for mistrial was denied. Cole sat down. Hannah was looking at the document on the screen, the case summary, the patient name, and I watched her read it the way I had watched her all week, with the attention of someone who has been reading the same person for 31 years. I watched her understand what the document meant, not just the legal meaning, not just the evidentiary weight of the judge saying 3 words that confirmed he remembered the defendant from the most vulnerable moment of his own life, but the fuller meaning, the meaning underneath the legal one. The file had been in the folder. Gerald had put it in the folder. I had put it in Gerald's folder. I had known for 3 years who Robert Hale was. I had known when I saw his name on the subpoena. I had known through 8 months of pretrial proceedings and 3 days of testimony, and I had said nothing and done nothing that would constitute leverage. And I had simply placed a document in a folder and waited for a man who had woken up from a cardiac event and remembered the anesthesiologist who had made the right call to find the document himself and recognize it for what it was. Hannah understood all of this, looking at the screen. I could see her understanding it. The court moved toward the close of the afternoon session. The jury was given instructions. The gallery shifted behind me, the quiet beginning to break into the low sound of people who have been holding something and are starting to release it. Then I heard movement in the 3rd row. Not the general movement of the gallery beginning to disperse. A specific movement, one person standing, the particular sound of someone rising from a bench with deliberateness rather than urgency. I turned. My mother was on her feet. She was not looking at the front of the room. She was looking at me, and her face held the expression I had seen from her at the end of difficult family conversations, the expression that was preparation for a sentence she had been forming. She opened her mouth. I spoke first. "You'll be fine, Mom." My voice was level. The room was not completely quiet yet, and my voice did not carry beyond the first several rows, but it was audible clean, without any inflection that would read as anger or performance or anything other than a statement of plain fact. You always are. I held her gaze for 2 seconds. Then I turned back to face the front of the room. I heard her sit down. I heard nothing else from the 3rd row. Not a word, not a sound, not the particular exhale that precedes a response. Her silence entered the space where a response would have been, and it stayed there, and it was the correct response. The only response that fit the sentence she had just received. The sentence she had been giving to me for 11 years at the end of every call I had made from a break room or a parking garage or a hotel room in the dark. The sentence that had meant, "You are capable, and I am confident in you, and also I am putting the phone down now." She heard it back. In a federal courtroom, before 60 people and 12 jurors and a judge who had just said he remembered me. She heard what it felt like to receive it. Gerald touched my arm once briefly and went back to organizing his documents, and I picked up my pen and I wrote nothing, just held it. And I looked at the front of the room and I waited for the session to close. The session closed at 4:51. Judge Hale read the charges into the record without inflection, the same measured delivery he had used for every procedural statement over the course of the week, as though the weight of the words was self-evident and required no additional emphasis from the voice carrying them. Identity theft, medical fraud, perjury, tampering with electronic record systems, conspiracy to suborn false testimony. He said each charge clearly and with a pause between them, and each pause had a different quality than the one before it, the way silences accumulate meaning as they add up, each one heavier than the last. I did not watch Hannah while he read them. I watched the jury. The jury had the particular stillness of people who have spent several days holding a question and have finally been given permission to set it down. Not relief, exactly. Something more like the settling of weight that has been redistributed into its correct position. 2 of them were looking at the bench. 3 were looking at their hands. The woman in the back row, who had been making notes in the small notebook since the first day of the trial, had her pen resting on the page and was not writing anything, just listening. and her face had the expression of someone who has heard something confirmed that they had been waiting to hear confirmed. I heard Hannah before I saw her, not a word, a sound. The specific sound of someone whose composure has been structural rather than emotional, and the structure has given way. It was not loud. It was the kind of sound that does not intend to be heard, that arrives without permission, that the person making it would stop if they could, and Hannah could not stop it. I turned then and looked at her, and what I saw was not the performance. The performance was gone. What was underneath it was a woman of 33 sitting at a plaintiff's table that had become something else entirely over the course of a week. Her hands no longer folded but pressed flat against the surface in front of her, her shoulders carrying something they had not been designed to carry. Her face doing the work that faces do when the story a person has been telling themselves for 15 years is no longer available to them, and there is nothing yet to replace it. It was not dignified. I had expected it to be, somehow. I had expected Hannah to hold the performance through the end, to maintain the composed surface even as the surface gave way beneath it, because the performance had always been her most reliable resource. But the performance requires an audience that can still be convinced, and there was no one left in that courtroom who needed convincing, and without the audience, the performance had nothing to sustain it. She made the sound again, quieter this time. Patricia Coles put a hand on her arm and said something I could not hear. Hannah did not respond to the touch. She was looking at the table in front of her at the surface that had held the plaintiff's documents for 4 days, and her hands were pressed flat against it. And what her face was doing was the private work of someone accounting for a loss they are still in the first seconds of understanding. I looked away. I looked at the third row. Kyle was not there. I had not noticed him leave. At some point during the afternoon session, while the bank records were being entered and the jury was holding the printed IT logs and the case summary was on the screen, Kyle Brennan had stood from the gallery and put on his jacket and walked out of the courtroom without saying anything to anyone. I had not seen it happen. I only knew it had happened because the seat beside my father in the third row, where Kyle had been sitting since the second day of the trial, was empty, and the space it left had the quality of a space that has been empty for some time rather than just vacated. His absence was its own kind of statement. It was the statement of a man who had understood at some precise moment in the afternoon that the thing Hannah had promised him was not going to materialize, and who had made the calculation that required no announcement and no explanation, and simply left. He had not looked at Hannah before he left. I was certain of that without having seen it, certain in the way you are certain of things you know about the grammar of a particular kind of person. His exit without a word was the most honest thing he had done since I became aware of his existence. My parents were still in the third row. They had not moved during the reading of the charges. My father was in his charcoal jacket with his hands on his knees, and he was looking at the bench, not at Hannah, not at me, at the bench, at the neutral institutional surface of a place where things are decided that he had not wanted to be decided here or anywhere. My mother was beside him with her hands in her lap, that familiar stillness, and she was looking at nothing specific or at something internal, at the space in front of her where the last week had organized itself into a shape that could not be reorganized. Neither of them looked at me. I did not require them to. Gerald was gathering the evidence folders, moving through his stack with the efficient economy of a man who had tried over 200 cases and knew exactly how to close the physical record of one. He pulled the folders in order, aligned the edges, placed them in his briefcase with the same care he brought to everything. He had not said anything since Judge Hale began reading the charges, and he did not say anything now. And his silence was not the silence of someone who had nothing to say, but the silence of someone who understood that what had happened in this room today belonged to me and not to the telling of it. Gerald had been in this business for 11 years. He knew when a moment was someone else's and when to leave it alone. I picked up my notebook. I turned to the page where I had written, on the first day of the trial, wrong dosage protocol, and checked the formulary date. I looked at those 2 lines for a moment. Then I closed the notebook and put it in my bag. I looked at the case summary still visible on the display screen. The top half of it, patient name and admission date and surgical team. My name in the anesthesiologist field in the plain 12-point font the hospital used for all its records. The screen would be cleared when the technical staff came to reset the room for the following morning session. Another case, another set of documents, another folder on the bench with its own weight of other people's facts. I thanked Gerald. I said it simply, without elaboration, because elaboration was not what the moment required, and Gerald was not a man who needed it. He nodded once and said he would be in touch in the morning with the procedural next steps, and I said that was fine, and he picked up his briefcase and walked toward the side door. I stood at the table for a moment after he left. The gallery was still emptying behind me, the low sound of movement and conversation beginning to fill the room as people released what they had been holding for the past several hours. I heard my name once from somewhere in the middle rows, and I did not turn toward it. I heard Hannah's attorney speaking to someone, her voice low and precise and stripped of the advocacy tone she had used all week, the voice of someone doing triage. I did not hear Hannah's voice. I picked up my bag and I walked out. The corridor outside the courtroom was crowded in the way courthouse corridors are crowded at the end of a session, people moving in both directions with the particular purposefulness of everyone being somewhere else in relation to where they just were. I walked through it without stopping, and I did not look for anyone I knew, and no one stopped me, and I reached the main doors and went through them, and the cold air hit the back of my neck, and I kept walking. 4 blocks. The same 4 blocks I had walked every morning and every evening for 9 days. The hotel lobby smelled like carpet cleaner, and the coffee they kept in a silver urn on the counter by the elevators. The man at the front desk nodded when I came in, and I nodded back, and I took the elevator to the 7th floor, and I walked down the corridor to my room, and I put the key card against the reader and went inside. The room was the same temperature it had been every day, the thermostat at 68, despite my adjustments. The parking structure visible through the gap in the curtain. Its grid of orange light sitting against the dark the way it had sat every night for 9 days. I stood in the middle of the room for a moment without turning on a light. I thought about calling someone. It was the same thought I had had at 2 in the morning in a hospital break room 6 years ago, and at various points in the years between then and now. The thought that arrives in the aftermath of something significant and suggests that the appropriate response is to tell another person about it. I held the thought for a moment, and then I recognized it for what it had always been, not a genuine impulse, but a habit of checking, a way of measuring the distance between myself and the version of a life in which that call would have a natural destination. The distance was what it had always been. I put my bag on the desk and I sat on the edge of the bed and I looked at the parking structure through the curtain and I let the room be quiet around me. I thought about the courtroom, about the specific quality of Judge Hale's voice when he said those 3 words and the way they had landed in the room, not as legal weight, but as human weight. The recognition of one person by another in a setting designed to process everything into the impersonal. I thought about Gerald placing his phone face down on the table 3 days ago, the deliberate, careful movement of a man who had just understood something. I thought about Elaine Brooks calling his office at 5:58 in the morning because she had looked at the records herself and found that she had been wrong and had not waited to be asked to say so. I thought about my mother's face when she heard her own sentence returned to her. I had not said it to wound her. I needed to be honest with myself about that. Sitting in the dark hotel room with the orange light of the parking structure through the curtain, the sentence had not been a weapon. It had been a fact. The same fact. It had always been stated in the same tone it had always been stated in, with the same assumption of capability behind it and the same absence of anything warmer than that assumption. I had given it back to her exactly as she had given it to me. Without cruelty, without ceremony, in the voice of someone stating something they have always believed to be true. That was the only voice I had ever heard it in. The difference was that she had heard it in a federal courtroom with 60 people around her and a week of evidence visible on a screen at the front of the room. And in that context, the sentence had acquired the full weight of everything it had never been required to carry when it was being directed at me. She would be fine. She had always been fine. That had never been the point. I lay back on the bed and looked at the ceiling, and I thought about what the morning would look like and the weeks after it, the procedural unwinding of a case that had been decided, the additional charges that would follow the criminal referral. Gerald had told me to expect the permanent bar from any medical or clinical facility that would attach to Hannah's record, the public documentation of everything she had done and why she had done it. I thought about the clinic. It would be mine to return to quietly, without announcement, the same way I had built it, the 3 treatment rooms and the 4 chairs in the waiting area, and the plant that was watered on Tuesdays and Thursdays, and the part-time staff who had continued working through the 8 months of proceedings because the operation was legitimate and licensed and had no reason to stop. I would go back. I would see patients. I would keep records. I would do the work. I fell asleep before I had planned to, somewhere between thinking and not thinking, and I slept without the short stretches and surfacings that had marked the nights before. I slept the way I slept after a long, successful surgery, completely, without reservation, the particular sleep of someone who has used everything they had and can now afford to stop. In the morning, I packed my bag. I'd packed it with the same order I had unpacked it 9 days ago, everything in its designated place, nothing left behind. I checked the bathroom counter and the desk and the drawer in the nightstand. I picked up the legal folder from the desk and held it for a moment. Not sentimentally, just taking its weight. Accounting for it the way you accounted for everything you were responsible for carrying, and then I put it in the bag alongside the notebook and the pen and the holding company documents and the case summary that had been filed back in its correct section where it belonged. I zipped the bag closed. I checked out of the hotel at 7:40. I put the bag in the trunk of my car in the small lot behind the building, and I sat in the driver's seat for a moment before I started the engine. The city was doing what cities do at 7:40 in the morning, moving the particular unremarkable motion of people going where they needed to go, none of them holding what I had been holding for the past 9 days, or the 8 months before them, or the 32 years before that. I started the engine. I did not have a destination in the sense of a place I needed to arrive at by a specific time. Gerald would call later in the morning. The procedural next steps would arrange themselves in the order they arranged themselves. The clinic would be there when I got back to it. I pulled out of the lot and onto the street, and I drove. The city moved past the windows, the buildings and the intersections, and the people at the corners waiting for lights to change. The ordinary motion of a Wednesday morning in a city that had not been paying attention to what happened in a federal courtroom for the past week, and would not have understood it if it had. I drove through it without a particular route, just driving, the way I had walked 6 blocks on the evening. Everything shifted and had not needed a destination then either. I was not going to the clinic yet. The clinic would be there when I was ready for it. First, there was the motion of a city that continued regardless, and the road ahead, and the quiet of a car moving through morning traffic with no particular urgency and nothing left to count. I thought about my mother's sentence and my mother's face. I thought about the beetle on the back step the summer afternoon when we were children, the popsicle that was almost nothing by the time I reached for it, and Hannah saying with complete sincerity that I should have eaten more when I had the chance. I thought about what it had taken to become a person who kept records. The city thinned as I drove, and the buildings changed, and the sky opened up ahead of me. That particular gray-blue of early morning in autumn when the light has not yet decided what it is going to do with the day, and I drove into it without adjusting the direction, just following the road where it went. She would say I would be fine. She'd always been right about that. She just never understood that being fine was something I did alone.